Good afternoon, everyone. Thank you, Dr. Chandyok, for giving this much needed break. I personally needed this cup of tea. So, and now I feel so guilty to be an MP. And, and particularly because I was also part of the parliamentary committee on home affairs to which these three bills were referred to. So, but thank you, Mr. Dave and Mr. Desai, of course. He has left. So for those very, very insightful comments, it was truly enlightening. Mr. Desai, of course, was invited by the committee to give his suggestions. There was elaborate discussions for about 3 months. So the original 3 bills were introduced in the Parliament in the month of August 2023, and then referred to the standing committee, of which I was a member and has been referred to. And the mandate of the committee was to give its inputs within 3 months, and we stuck to the mandate. So on 10th of November 2023, we submitted our report to the Parliament, and the bills were reintroduced in the month of December 2023 during the monsoon session, and was passed by the Parliament. Not a happy situation. The entire opposition was expelled. So, being a member of Biju Janata Dal, it's often a tricky situation because you do not know who to sympathize with. And so this is a disclaimer because everything that I say are my personal views and not necessarily the views of my party or of the committee that I was a part of. And I would rather agree to most of what Mr. Dave and Mr. Desai said, but since we are a democracy, oftentimes smaller parties and I spoke on behalf of my party on the floor of the House when these bills were being discussed, or rather the bills were being passed without discussions. So I spoke, and you can it's there in the public domain, and you can find out for yourself that I have agreed to most of the things that were pointed out by 2 gentlemen who spoke before me. So let me express my gratitude to Bar Association of India, Prasant, and others for inviting me to be part of this Rule of Law Convention. And I would like to particularly commend the BAI for dedicating this year's theme to these 3 new acts, because the impact is going to be monumental, not only for lawyers and citizens, not only for lawyers, but also for IOs, investigating agencies, for judiciary, but most importantly for the common citizen of this country. I mean, much has been said about how 320, 420, 376 were part of the popular culture, popular folklore. In fact, there are many Bollywood movies, the Sri 420, many Bollywood dialogues that refer to the sections of IPC and was easily understood across the country. So now it will be very, very difficult. At least the first couple of years will be extremely difficult for everyone, particularly for the common litigant and citizen of this country. If you go for a simple textual comparison, there is hardly any difference between the IPC and the BNS. By and large, most of the provisions are the same, verbatim, and I will point out some of the differences where I have concerns, and some of the provisions where I think good sense has prevailed. To start with, Mr. Chandyok wanted to know why the Parliament, what was the parliamentary intent to bring these 3 legislations. I'll tell you, I mean, of course, the statement of objects and reasons, we have all gone through, and we broadly know what was the parliamentary intent. But beyond the statement of objects and reasons, when we were deliberating this in the committee, and otherwise when we were being briefed by experts, including former Supreme Court judges and High Court judges, many vice chancellors, many retired director generals of police, and so on and so forth, and of course eminent lawyers. Uh, the idea was that this will bring in ease of justice. And I think it was Mr. Desai who spoke of the Jan Vishwas Bill. I'm not sure, pardon me, Mr. Davi, if it was you. The Jan Vishwas Bill was passed by the Parliament in the monsoon session of 2023, which decriminalized a large portions of offences. So there are many offences which were in the statute book, which were really silly. So to give an example, if a labor contractor forgot to whitewash the washroom, which was being used by the workers every 6 months, then the contractor could be prosecuted. This was in the statute book. So there are many such, there were many such provisions which were done away with, thankfully, through the Jan Vishwas Bill. And this was a continuity. This was a continuation of making life easier for the citizens of this country. So ease of living and ease of justice were two broad concepts which dictated the government of the day, meaning the present government, to bring in these bills. Yes, it is true that the language and the structure of IPC had become archaic, had become outdated. Mr. Dave spoke about canon. There are many such illustrations. Chariot. There are many references to the British Crown, Her Majesty. So it was certainly necessary to remove some of those languages. It was necessary to be in tune with the massive transformation that the society has witnessed because of technology, because of globalization, or because of change in societal values, attitudes. What was acceptable in 1860 may not be acceptable today, or what was probably not acceptable in the 19th century has become by and large acceptable today. Homosexuality, for instance. So it was necessary to give shape to this evolution of society, technology, etc. And over the years, many specific laws had come into our statute books through NDPS Act or Juvenile Justice Act or the Motor Vehicle Acts. So you had a generic law, and then you had the specific acts, and it was sometimes overlapping, sometimes conflicting. So it was necessary to also to bring in more clarity, and that was one of the key reasons why the IPC, CRPC, and the Evidence Act had to be overhauled. And if you go to the speech of Honorable HM, Home Minister, say Amit Shah, when he was justifying why these acts were being brought in, he mentioned about the fact that the three colonial laws were by the Britishers, of the Britishers, and for the Britishers to perpetuate their continuity, their hegemony in India. And BNS, BNSS, and the Bharatiya Sakshya Adhiniyam are by the people of India, for the people of India, and of the people of India through the Parliament, which, as you all know, represents the will of we the people. So, be that as it may, these were some of the reasons. Of course, it's not comprehensive, it's not exhaustive, there are other reasons, but these are some of the reasons that were cited either in the committee deliberations or in the Parliament, on the floor of the House, by the lawmakers to bring in these laws. I don't necessarily subscribe to all of this, but certainly I do subscribe to some of this thinking. And one key objective seemed to do away with the colonial hangover. Yeah, this is a favorite pastime of this government to eliminate anything and everything that has some colonial connotation. So the Indian Penal Code, of course, was more punitive. The title itself had penal. So the Bharatiya Nyaya Sanhita. So the objective was that the law should be more rehabilitative rather than punitive. Hence the word justice, Nyaya, Bharatiya Nyaya Sanhita. And also in CRPC, it's not criminal procedure code anymore. And this was also pointed out by learned Attorney General this morning when he said that the new law is to be called or has been called Bharatiya Nagrik Suraksha, so giving security and the comfort to citizens of this country. Now, there are many positives. Let me start with the positives because I don't want to add to the gloominess of this room. So let me let me say that there are enough number of positive elements in the three bills, and since we are talking only about BNS, I'll stick to BNS. First and foremost, this idea of having community service as one of the punishments for petty offences, right? And Mr. Dave spoke about it. I think that's a very, very progressive development. I think that will A, build trust in our citizens, and B, declutter our prisons. So today, you know, overcrowding of prisons is a reality. So I think that will certainly help with these objectives. 309, section 309, attempt to commit suicide. You know, a person commits suicide or attempts to commit suicide when she or he has lost every hope in life and needs our support, our counseling. And when she or he fails in that attempt, you punish that lady or gentleman. How cruel can one be? So I think that is probably, in my view, that is the single most welcome element that section 309 IPC has been done away with. 377, 497 adultery. I mean, of course, we can have our own arguments and debates whether 497 morality and its impact on society, should it be there. Most of the committee members were of the view, Mr. Chandiok, that 497 should be there in BNS as well. But I must really compliment and thank the government of the day that both 377 and 497, even in fact 377 as well, most of the members were of the view that 377 and 497 should be there in the new bill. But sincere compliments to the government that this were done with. 3010, of course, 3010 and 11 have been mentioned by Mr. Dave, the definition of thug and punishment for thuggery. One welcome provision is that the BNS has streamlined, you know, the offences and penalties. So previously in the IPC, there were separate sections for the offences and for the associated punishments. So now in the BNS, you have the offences and the associated punishments in the same section itself, which I think has simplified the format. I mean, of course, we might have different view, but I think that is a welcome change. Section 111, organized crime, petty organized crime 112, 113, terrorist acts. Enough has been said about these three sections. But I think given the challenges of present day India, I think there was need for separate sections to tackle with terrorist activities, to tackle with crimes such as money laundering, smuggling. Of course, we have specific legislations for many of this, but I think there was need for enacting, for having provisions for these offences in the generic statute as well. So I welcome having organized crime or petty organized crime or terrorist acts in the BNS. Transgender has now been recognized. Very, very welcome move. Section 2, subsection 10 defines transgender. The definition has been taken from the Transgender Act of 2019. The BNS does not define transgender, but I think we have given the due respect to the transgenders by having them as a third gender, a separate gender. Now, let me come to the challenges and concerns. First and foremost is this article. It is so prophetic that this morning, Justice Amanullah apprehended that these three bills might be challenged and the Supreme Court might be asked to adjudicate. And I see that happening. The title of the acts itself might be challenged because it's foul of Article 348, 1 of the Constitution. And for the convenience of the audience, I have highlighted it in red. The title is section 1 of the BNS. And there were members from DMK, there were members from TMC, and I'm from Biju Janata Dal, I'm from Odisha. So Hindi is not my first language. So we vehemently opposed having the titles. I mean, I have nothing against having the titles as they are, Bharatiya, Nyaya, Sanhita, or BNSS, or Sakshi Adhiniyam. But A, it might be unconstitutional, and B, I think, imagine a lawyer in remote Tirunelveli or Kalburgi or somewhere in Karnataka, or you know, it might be really hard for them to pronounce these names. So I mean, why complicate matters when you could have just had simple English names? You know, if the idea was to remove penal, the word penal or the word criminal, then you could have thought of some different words. But I think these Hindi titles, I think, is unfair for a country which is as diverse as ours, and particularly when there is so much of sensitivity with regards to language, particularly in states like Tamil Nadu or Kerala or Karnataka. So why fuel unnecessary controversies? So I think that's the first objection which I had, and there was mighty debate in the committee, in the parliamentary committee on this. But because we are a democracy, and then of course the majority voice counts, so this was overruled. Secondly, several offences, they overlap with specific laws. Now I've given you, sorry for the font, size of the font, but you know, I'll give just two specific examples. One is the Motor Vehicle Act or the Juvenile Justice Act, and there are other, the Food Adulteration Act. There are many, you know, in many cases, you know, the BNS and the specific laws, they have different penalties, they have different procedures. So this would lead to multiple regulatory regimes. This would lead to, you know, more compliance costs. Potentially, this would lead to more confusion. So I think that clarity is lacking, which I think the new law has not addressed. The third concern which I have is with regards to what is popularly known as mob lynching. Now, the IPC did not have any specific provision to punish the offence of mob lynching or hate crime. So the punishment for mob lynching, the police would register a case under 302, you know, for murder, and we all know that we are living in an age where mob vigilantism, mob lynching is a reality. In fact, the Supreme Court itself had said in Tehsin Punewala versus Union of India that it had urged the government of India to bring in a specific law to curb the menace of mob lynching. Now, I'm glad that the BNS has done that. The BNS has recognized this and has paid heed to the direction of the Supreme Court. And there is a new offence of mob lynching, though the BNS does not use the phrase mob lynching per se, but it is there under the offence of murder. But the issue here is that the issue here is that religion has not been identified as one of the grounds. Now, in the Tehsin Punewala versus Union of India case, the Supreme Court had categorically recognized religion as one of the prominent grounds in the instances of mob lynching, which BNS has failed to do. So BNS has employed the phrase personal belief or any other ground, any other similar ground. Now, I admit, I concede that it is possible to interpret the scope of this phrase broadly to mean religion or to bring religion within its ambit. But to me, it seems rather odd that religion has not been, you know, specifically included in the definition or in the section. So probably this is deliberate, but I think this is a very sad omission, given the state of affairs. this has been spoken about gender, the uh, uh, the offense of rape. Both my previous learned speakers have spoken about this. The statement of objects and reasons specifically highlights that the BNS aims to be gender neutral, and many of the provisions of BNS have in fact been made gender neutral. For instance, the offences, the provisions relating to kidnapping, procuring, hiring, or employing minors to commit offences, they have all been made gender neutral. But sadly, the offence of rape has not been made gender neutral, which is I think very unfortunate. We know that men are routinely raped in our hostels, in our prisons, and otherwise in largely in the society. The Law Commission in its report in the year 2000, Justice Verma Commission in 2013 had highlighted this and had urged the government to make the offence of rape gender neutral. So I mean, it's not that only women are the victim always, men are also victim of rape many a times. So I'm rather disheartened that BNS does not protect men against sexual assault, particularly because now there is no 377 in the BNS. Right. So in Navtej Singh Johar versus Union of India, the Supreme Court held that the provisions of 377. Okay. So in Navtej Singh, as you all know, consensual sex between adults of the same gender was decriminalized. But the Supreme Court added that the provisions of 377 will continue to govern non-consensual acts against adults or acts of bestiality. Now, in the absence of 377 or any provision akin to 377 in the BNS, how are you going to punish bestiality or acts involving non-consensual sex? So, sexual assault against men. So, there is no provision in the BNS. So, this is I think quite a serious omission which needs to be relooked. There is another concern in the BNS, which is the lack of distinction in punishing attempt or abatement and completed offence. Section 111, organized crime. The offence, the BNS creates no distinction between the attempt to commit an organized crime and the attempt or abatement of the offence. Similarly, Section 104, murder committed by a life convict. Section 1092, this is BNS, 104 of BNS and 109 subsection 2 of BNS, which is attempt to commit murder by a life convict. So for both the offence and the attempt to commit that offence, the punishment is the same, which is rather arbitrary in my view. Then the other concern in the BNS is, sorry again I keep using BNS, Mr. Dave, so it's pretty comfortable using BNS rather than the long form. Section 61 of BNS has defined criminal conspiracy, which is akin to 120A of IPC. The difference being that you have this phrase with the common object of, which wasn't there in the 120A IPC. Now we all know that criminal conspiracy and common object are different concepts. Now common object has been used to denote meeting of minds or shared objectives in committing an offence, which is not necessarily what criminal conspiracy is. So now we don't know what the intention of the parliament was in adding this phrase, with the common object of, while defining criminal conspiracy, and this will potentially lead to confusion. Section 113 has been comprehensively addressed by both my predecessors. This is similar to Section 15 of UAPA. Now, the concern here, again, this has been pointed out before. An explanation is added to the section, which allows an officer not below the rank of an SP to decide whether to prosecute a terrorist activity or an act under UAPA or BNS. But what is the basis of making that decision? On what basis will the Superintendent of Police decide whether to prosecute under BNS or UAPA? that clarity is lacking. So this is bound to cause confusion. So again, this should be relooked. Uh, Organized crime, lot has been said about it. Here, the concept of economic offences has been brought in for the first time, which I think is a welcome move. But it is unclear whether the provision also covers foreign entities or organizations, criminal organizations operating outside the territory of India, but committing crime in India. Whether they will be covered, this is unclear. So we don't have that clarity. Now another personal concern of mine is with regards to the definition of petty organized crime. Now, selling of public examination paper, I would like to see a show of hands. Is this a petty crime? I mean, can you club it with snatching? Can you club it with theft? This is what precisely has been done. I mean, it's a huge racket. It's a huge syndicate. We are playing with the lives and career of our youth, of our children. And you put it, and in fact, I was so vehement in my opposition to have this in the section 1112, and club it with other so-called petty offences such as snatching and theft. But of course, it still continues there. So I think at some point this should be looked into. Just two more points and then I'll conclude. Section 226, as I said before, probably the single biggest or the single best outcome of the repeal of IPC was 309, repeal of section 309, attempt to commit suicide. But a new section has been inserted, section 226, attempt to commit suicide to compel or restrain exercise of lawful power. Now, I can sit on hunger strike, so will I come under the ambit of 226? Because sitting on hunger strike for a couple of days might cause a death, right? So we see that is a democratic process. It's an expression of our democratic right to sit on strikes and also on hunger strike. So does it now going to cause an offense under 226? We don't know. So I'll stop with that. I'll be happy to take if there are any queries, but I think there are a lot of good provisions in IPC, CRPC, in the Evidence Act. For instance, the concept of zero FIR, concept of EFIR have been introduced. So now imagine this is such a great service, particularly for women, for rural women, because they have to go to the police station to register their FIR, and you know how things go in our police stations and how they are dealt with. So now the concept of EFIR and zero FIR, I think that will reduce the burden on citizens, particularly on the women folk. I wish there was some provision related to multiple FIRs. Without naming anyone, you know that in the past we have seen multiple FIRs were lodged against a particular individual, cutting across party line for the same offence. One in Kerala, one in Calcutta, one in Delhi, one in Nagpur. So Supreme Court had to step in to club all these FIRs. So I guess the lawmakers should have taken care of this, and I think something should have been introduced in the bill, in the three bills. So hit and run cases, as you probably know, that has been put on hold because of the opposition from the All India Motor Transport Congress. Now this has been made more stringent. But the idea was that the concept of golden hour, which is a term which has been introduced in the Motor Vehicle Act as well. That's the most important time when a person's life can be saved. So if a motor vehicle hits a victim and flees from the scene of the crime and does not report it to the nearest police station or the magistrate within a reasonable time, then that offence has been made more stringent. So I think the opposition of the All India Motor Transport Congress is not justified. I think after the elections, the government will probably will lift the hold which it has put on Section 106 subsection 2, which is popularly known as hit and run. But I think that's I don't think that's a harsh provision, because it is our civic duty. You know, all of us can have accidents and can ourselves indulge in accidents or cause accidents, but it is our civic duty to do the next best thing once an accident happens. So I'll stop with that, Mr. Chandio, and
thank you so much, sir. Thank you very much for that illuminating address.
Mr. Chandio, if you give me 1 minute, Mr. Desai, I think in lighter vein, spoke about having a separate digital. Yeah, actually, I think he was not. I think he was serious about it. The Parliament is contemplating bringing something to be called the Digital India Act 2024 or something. I hope it's not called the Bharatiya Internet Done Sanhita or something. So yeah. Thank you.
Thank you.